Obligations with subtopic nature and effect of obligations, and this is already the last part or part 5. We're done discussing the obligation to give, and please recall that your obligation to give is your real obligation. Also, tapos na tayo with the obligation to do, and your obligation to do is your passive personal obligation. Your obligation not to do that is your negative personal obligation. We are also done with the breaches of obligations, and what did we say? We can classify the breaches into two, and that is the voluntary breach and the involuntary breach. For your voluntary breach, the applicable article is Article 1170. So, ano ang sinasabi ni Article 1170? Fraud, negligence, delay, or contravention of the tenor of the obligation are considered voluntary breaches. And in this case, if it is a voluntary breach, the debtor is liable for damages. How about if it is an involuntary breach? The applicable article is Article 1174. Again, Article 1174 is about the famous fortuitous event. And if there is a fortuitous event, ano ang rule? The debtor is not liable for damages. But is that rule absolute? The answer is no. May mga exceptions yan. In this video, what we are going to discuss already is the remedies available to the creditor in cases of breach. What are therefore the remedies available to the creditor in cases of breach? Well, we can classify them into two, and that is your primary remedies and subsidiary remedies. So what are considered primary remedies? First, you have the action for performance. Take note that the creditor can file either an action for specific performance or an action for substituted performance. Next, the creditor can also file an action for damages as well as an action for recession. For subsidiary remedies, the creditor can exhaust the property of the debtor, or the creditor can file an action for subrogatoria or action pauliana. When can there be an action for specific performance? Let's review. Ulitin natin yung mga sinabi na natin before. If the thing involved is a determinate thing or specific thing, the creditor can compel a specific performance. Reason or why? Because under the law, the obligation of the debtor is to perform the obligation specifically. Basis, Article 1165 and Article 1244. Ulit, ano ang sinasabi ni Article 1244? Debtor, you cannot compel the creditor to receive a different one, although the latter may be of the same value or mas mahal pa than that which is due. When can there be a substituted performance? Answer, if the thing involved is indeterminate or generic. Because here, the creditor can ask for the performance of the obligation because the debtor has the obligation to deliver a thing which is neither of superior quality nor inferior quality. Basis, Article 1246. Again, let's read what is Article 1246. The creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. What if the debtor does not want to perform the obligation? What is now the remedy of the creditor? Your answer is in Article 1165. Article 1165 says that the creditor can ask that the obligation be complied with at the expense of the debtor. Please take note also that there is a substituted performance in passive personal obligation or your obligation to do. Again, let's recall ano ang sinabi natin. In passive personal obligation, the creditor can have the obligation performed or executed at the expense of the debtor. Basis is the first paragraph of Article 1167. Likewise, the creditor can ask that what has been poorly done be undone. Basis is the second paragraph of Article 1167. What if the obligation is purely personal? Ano ang sinabi natin dito? Our example was, Kuya Will, there is this Christmas party. Gusto ng company, si Kuya Will ang mag-host. But later on, si Kuya Will is nag-back out for no reason at all. So what happens in this case? Can the creditor ask for substituted performance? Answer no. There is no substituted performance if the obligation involved is a purely personal. Meaning to say, the obligation cannot be performed by the creditor or it cannot be performed or executed by another person with the expenses shouldered by Kuya Will. Reason: because the personal and the special qualification of Kuya Will was the principal motive for the establishment of the obligation. What is now the remedy of the creditor in this case? The only remedy of the creditor is to file an action for damages. In negative personal obligation or your obligation not to do, according to Article 1168, the debtor, if the debtor does what has been forbidden him, it shall also be undone at his expense. Another primary remedy is your action for recession. So what is the applicable article? That is Article 1191. Take note that Article 1191 applies only if the obligation is reciprocal obligation. So those which are created or established at the same time out of the same cause and which result in mutual relationships of creditor and debtor between the parties are reciprocal obligations. Example is the contract of lease. Bakit siya naging reciprocal obligation? Because the lessee has the obligation to pay the rental, the lessor has the obligation to permit the use of the thing leased. Another example is your contract of sale. Bakit siya naging reciprocal obligation? Because the vendee or the buyer has the obligation to pay the price and the seller has the obligation to deliver the thing sold. Another important thing to remember about Article 1191 is the necessity of judicial action. Here, the right to rescind the obligation is a right which belongs to the injured party alone. Take note ha, injured party lang ang pwedeng magpa-rescind. However, it is essential that it must be invoked judicially. Basis is the third paragraph of Article 1191. Ano ang sinasabi ni Article 1191, third paragraph? It is the court that shall decree the recession claim. Next, take note that in Article 1191, the nature of the breach must be substantial or fundamental. Recession will not be permitted if it is only a slight breach or a casual breach of the contract. Take note also that the injured party has alternative remedies. Basis is your Article 1191, that is the second paragraph. The injured party may choose between the fulfillment of the obligation with damages or the recession of the obligation with damages. So these remedies are alternative and not cumulative. What is the effect of recession? When an obligation has been rescinded, it is now the duty of the court to require the parties to surrender whatever they may have received from the other. In other words, the parties must be placed in their original situation. What is the effect of recession upon third persons? Ano ang sinasabi ni Article 1385? Recession can be carried out only when he who demands recession can return whatever he may be obliged to restore. But take note that recession will not take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. We'll discuss further Article 1191 kasi favorite topic sa bar exam. Article 1191 can be applied only to reciprocal contracts which contain no resolutory conditions. What is the meaning of that? If the contract contains a provision, a resolutory provision, by virtue of which the obligation may be canceled or extinguished by the injured party in case of breach, then judicial permission is no longer necessary. Meaning that is allowed because the only limitation set by law on the exercise of the right to terminate a contract is that it must not be contrary to law, morals, good customs, public order, or public policy. So please take note kung kaya nyo tong isulat sa bar exams kasi maganda tong pambanat ng bar exams. If the right to rescind is implied, only if it is not expressly granted. So, if the right to rescind is expressly recognized, therefore, no right can be said to be implied. For application, let's take a look at this 2008 bar exam question. Tingin agad sa tanong, can XY Corporation unilaterally and immediately cancel the contract? So there is a contract between AB Corporation and XY Corporation whereby AB Corporation agreed to construct the research and lab facilities of XY Corporation. Under the terms of the contract, AB Corporation agreed to complete the facility in 18 months and the total contract price is 10 million. XY Corporation paid 50% of the total contract price. The balance is to be paid upon completion of the work. The work started immediately, but AB Corporation later on experienced work slippage because of labor unrest in his companies. The employees of AB Corporation claimed that they are not being paid on time, hence the work slowed down. As of the 17th month, work was only 45% completed. Ang pinag-uusapan nila is 18 months tapos na. So when it became certain that the construction could not be finished on time, XY Corporation sent written notice canceling the contract. So can XY Corporation do that? How can we answer this question? Paano mag-isip? First, determine the kind of obligation. Since the question calls for a recession or cancellation of the contract, determine the kind of obligation. If it is a reciprocal obligation. Second, determine if there is a resolutory provision in the contract. What is the meaning of that? Determine if there is a provision in the contract that the party can cancel or can rescind the contract. So in this case, ano ang makikita mo sa problem? Obviously, wala. Therefore, Article 1191 is applicable. Ano ang sinasabi agad ni Article 1191? In case one of the debtors should not comply with what is incumbent upon him, the power to rescind obligations is implied. Next, ano ang sinasabi ulit ni Article 1191? It is the court that shall decree the recession claim. So, what is your answer here? The answer is the XY Corporation cannot unilaterally and immediately cancel the contract because there is a need for a judicial action for recession. Meaning to say, in this kind of obligation, a reciprocal obligation, recession is allowed, but it can only be invoked judicially. Question: are the provisions of Article 1191 applicable to obligations arising from contract of lease? Answer: no. Bakit? Ano ulit ang sinasabi ni Article 1191? The injured party has a choice between the fulfillment of the obligation with damages or recession of the obligation with damages. Ano naman ang sinasabi sa contract of lease? The applicable article is Article 1659. If the lessor or the lessee should not comply with the obligations, the aggrieved party may ask for the recession of the contract and indemnification for damages or only the latter. So more or less, pag binasa mo si Article 1191 and 1659, parehas lang. So where lies the difference? If you read closely Article 1191 dyan sa third paragraph, ano ang sinasabi? the court shall decree the recession claimed unless there is a just cause authorizing the fixing of a period. So what is the meaning of that? In Article 1191, courts have the discretionary power to refuse the recession of the contracts, whereas in Article 1659, there is no such discretionary power granted to courts. This is the reason why Article 1191 is not applicable to obligations arising from contracts of lease. So please take note kasi nakita ko to, tinanong to sa bar exam, although luma na, mga 1960s or 1970s. Kaya lang, baka biglang tanungin ulit at hindi nyo alam. So, please take note. Another question, are the provisions of Article 1191 applicable to obligations arising from contracts of partnership? So, ang pinag-uusapan na natin dito is contract of partnership. Kanina, that was a contract of lease. So, what is the answer? Answer is Article 1191 cannot be applied to contracts of partnership where one of the partners fails to pay the whole amount which he has bound himself to contribute to the common fund. Bakit? Because there, in this scenario, the applicable article is Article 1786 and 1788. The Article 1191, take note that it applies only to resolution of reciprocal obligations in general, whereas Articles 1786 and 1788 refer to contracts of partnership in particular. And ano ang naalala nyo sa statutory construction? What is the rule? Special provisions prevail over general provisions. So that is the basis, or that is your reason why the provisions of Article 1191 is not applicable or does not apply to obligations arising from contracts of partnership. Take note again ha, kasi tinanong din to sa bar exam although luma na. Next item I want you to remember is the difference between Article 1191 and Article 1380. Ano ang Article 1191? Again, it is a recession of reciprocal obligations, whereas your Article 1380 is the recession of rescissible contracts. So again, what are the rescissible contracts? The answer can be found in Article 1381. So those contracts in behalf of wards, or those contracts in behalf of absentees, or contracts in fraud of creditors, or contracts referring to things under litigation, and all other contracts especially declared by law to be the subject to recession are your recessible contracts. So ano ang difference ng dalawang ito? First, your Article 1191 applies only to reciprocal obligations. So, only reciprocal obligations may be resolved in Article 1191. In Article 1380, it applies to contracts whether unilateral or reciprocal. So, unilateral contracts and reciprocal contracts may be rescinded under Article 1380. Next. In Article 1191, ano ang sinasabi dyan sa third paragraph? The law expressly declares that the courts shall have a discretionary power to grant an extension for the performance of the obligation provided that there is a just cause. How about in Article 1380? There is no power of the courts to grant an extension of time for the performance of the obligation. In 1191, the only ground there is the failure of one of the parties to comply with what is incumbent upon him. In Article 1380, there are several grounds or several causes, and that could either be lesion, fraud, or others expressly specified by law. The last difference is in Article 1191, take note that it can be instituted, or the recession can only be instituted by a party to the contract. Ano ang sinabi natin? Only the injured party can file an action for recession. In Article 1380, that is not the case because the recession can be instituted not only by a party to the contract but even by a third person. So please take note of the difference between Article 1191 and Article 1380. Let's go now to subsidiary remedies. So what are the subsidiary remedies of the creditor? The creditor can exhaust the property in possession of the debtor. Also, the creditor can file an action subrogatoria. So what is an action subrogatoria? The creditor will be subrogated to all of the rights and the actions of the debtor, save those which are inherent in his person. And last is the creditor can file an action pauliana. That is, the creditor can impugn all of the acts which the debtor may have done to defraud him. So what is your basis? That is your Article 1177. What is action subrogatoria? Let's illustrate para mas lalong maintindihan. If si debtor may utang kay creditor, it is also possible that there is a third person na may utang kay debtor. So in that case, or in this scenario, your third person is now the debtor, and si debtor or si original debtor is now a creditor as to the utang of the third person. But the problem is the debtor is tamad. He simply fails or neglect or refuse to collect any credit which he may have against a third person. So in that case, ano ang sinasabi ng batas? Sabi ng batas, creditor, you have the right to exercise all of the rights and bring all of the actions which the debtor may have against third persons. And that is called action subrogatoria. Meaning to say, the creditor can go after the third person. But take note of the bata, only if he complies with the following requisites. So what are the requisites? Number one, the debtor to whom the right or the action properly pertains must be indebted to the creditor. Second, the creditor must be prejudiced by the inaction or the failure of the debtor to proceed against the third person. And last is the creditor must have first pursued or exhausted all of the properties of the debtor which are not exempted from execution. So only if the requirements are complied with, then the creditor can file an action subrogatoria. Let's go now to action pauliana. What is action pauliana? Let's illustrate para mas lalong maintindihan. If si debtor may utang kay creditor, pero ang ginawa ni debtor is he alienated or he conveyed his properties to third person. The purpose is to defraud the creditors. Ano ang sinasabi ng batas? Sabi ng batas, creditor, or if you are a creditor who is prejudiced by the act of the debtor, you have the right to impugn or attack directly that act of the debtor by means of a recessory action. So pag pinag-uusapan si action pauliana, actually that is an action to rescind a contract in fraud of creditors. That is your Article 1381, recessible contracts that are undertaken in fraud of creditors, they can be rescinded. What is the requirement of the law? First, here the requisites is that the plaintiff asking for recession has a credit prior to the alienation. Ano ang ibig sabihin niyan? At the time of the alleged fraudulent alienation, dapat si creditor nag-i-exist na. Second, the debtor has made a subsequent contract conveying a patrimonial benefit to a third person. The creditor has no other legal remedy to satisfy his claim, and the act being impugned is fraudulent. And the last requisite is the third person who received the property conveyed if it is by onerous title has been an accomplice in the fraud. So only after complying with these requisites of the law that the creditor can file an action pauliana. Take note that your action pauliana is an action of a last resort. Bakit? Ano ang sinasabi ng jurisprudence? For as long as the creditor still has a remedy at law for the enforcement of his claim against the debtor, the creditor will not have any cause of action against the creditor for the recession of the contracts entered into by and between the debtor and another person. Second, an action pauliana, it accrues only when the creditor discovers that he has no other legal remedy for the satisfaction of his claim against the debtor other than an action pauliana. Take note also that in action pauliana, it presupposes that the creditor has exhausted the property of the debtor. Meaning to say, in action pauliana, meron ng judgment, meron ng writ of execution issued by the trial court, and yet the sheriff failed to enforce the judgment and the sheriff failed to satisfy the judgment of the court. This is the reason why in action pauliana, it is an action of last resort availed only after the creditor has exhausted all the properties of the debtor, not exempt from execution, and after all other legal remedies have been exhausted, but they have been proven futile. So that is your action pauliana. Please take note. So this is the end of the video. Thank you very much for watching. Our next topic is already the kinds of obligation. Thank you very much and good day.